Good evening, everyone. This is Pete Canlin, the Executive Director with the American Kratom Association. I'd like to thank everyone for joining us tonight for our latest webinar, What to Do if Kratom is Scheduled. On the call with us, we have Dave Herman, who's the Chairman of the American Kratom Association, and Mac Haddo, who's the Senior Fellow on Public Policy. Mac will be providing us a little bit more information later on in the call. Just beforehand, folks are on mute. We've got a lot of folks on this call, so we've put everyone on mute. We have a list of questions that we'll go through at the end, I'll monitor the chat area over here to see if there's any new questions, and also we'll be recording this and posting it later for people to view. With that, Dave, I'll turn the time over to you.
Thank you, Pete. We know there are a lot of people with a lot of questions, a lot of fears, a lot of anxieties. And so tonight we're going to try to cover some of those issues with you, starting off with criminality of Kratom in the event of a scheduling, moving on to what we're actually going to do as a community, and then ending with questions that hopefully answer whatever we haven't covered. To begin with, what to do if Kratom is banned, is scheduled. We fully intend to get participation from all of you. In the past, there have been some concerns that we weren't for a rally or we weren't for this or other. We wanted to keep our powder dry because if the day came, and we hope it doesn't come, but if the day came where we're scheduled, we're going to need every one of you. We're going to have rallies. We're going to make noise, and people are going to hear from us. We've got an excellent legal team. We spent a lot of time with them. They're doing a lot of research for us. And we're going to do this in a disciplined, orderly manner because, frankly, all of us have the same goal. It's keep Kratom legal. And so we're going to follow the best practices that help us achieve that. And we're going to use every resource we've got. And that includes looking at all of you as to what you do on your day-to-day lives. We hope to have a group of you that are law enforcement officers. We hope to have a group that are paralegals. We hope to have pharmacists. We hope to have doctors, because the more disparate groups that we can put together to show that the average American is a Kratom user, it's going to help us. So engaging every resource to fight the scheduling process is a big part of our planning. What can you do? Well, number one, if you believe that we're doing the right things for you and that our hearts are in the right place, because we certainly believe they are, then listen and participate and be part of us. Because with you together, I think we can make a lot of noise that's going to be heard very loudly. When the comment period, if a comment period comes, we need to engage in that. Every step of the way, and Mac's going to share most of those steps with you today, but every step of the way, we need your involvement. And one of the analogies I like to use a lot is if you were an election process, and it doesn't matter who you are, but if you were a Democrat and you wanted to win an election, you'd have to change a Republican to a Democrat to get votes. That's how it works. And we think that as the Kratom community grows, we need to reach out to people who aren't necessarily part of our community, but understand the rights of every American to ingest whatever they want to as long as it doesn't hurt them, and that's a right we're all fighting for. So engage in the comment periods. We want you to work with network of family and friends and grow our base of people. Contact the elected people who supposedly serve us, and we want to make sure they do. And if they know you're from their district, they're going to hear you. And if a lot of people from your district come in, they're going to hear you. So that will be part of the process of what an individual can do. Getting to the nitty-gritty, we get asked this question constantly. What happens if Kratom is banned? Am I a criminal? What's going to be? Well, if it becomes a Schedule I Controlled Substance Act item, possession is a crime. Now, generally, prosecutors use drug possession as a secondary charge, but we're seeing things around the country that are disturbing, where we fear things can happen, and list a little bit there. But if you're out in the car and you get stopped for a broken taillight and a law enforcement officer sees Kratom in your car, that's criminal. You can go to jail for it. It's a Schedule I item in that case. So we think there's a lot of areas where We don't anticipate, but there'll be real problems. We don't think the DEA is coming to your house and going to ravage through your closets looking for kratom. But there are a whole lot of levels. When we do things, we do a 3-level review. And we look at a federal, and we look at a state, and we look at a local. All of those are in play when this comes to be. Pete? Yeah. Well, that's the one I just mentioned. How will the government discover that I possess kratom? Well, number one, they can find it in a traffic stop. If they can take this from simple possession to intent to distribute, you're now a dealer, and you'll suffer the jail time a dealer would normally get. That's a worry. A vendor under extreme duress could very well give up a customer list, although to date, the vendors have been really good about holding on to those things. But if they have to for themselves, your name's going in the hamper. And again, with criminal a situation there, that's very dangerous, and we're worried about that. What to do if I am charged with possession? And we have variations on this theme that are occurring right now in some states where it's not legal in different areas. Do not rely on friends or family for advice. Just don't do it. The internet is a wonderful thing that tells you absolutely nothing germane to your particular case. You got to get a lawyer. You got to get a lawyer who will fight for you. We at the American Kratom Association are happy to provide information, lead people to certain areas, but we can't get involved in these cases individually. And number one, we're not lawyers. So the first thing that happens in the event of an interdiction is you get a lawyer. And if you need that lawyer to be educated on what kratom is, we're happy to do that. And here, when we go to the scheduling process, let me turn it over to Mac Haddo.
Dave, thank you. And let me emphasize to people that we don't believe at this point that there is any imminent threat of scheduling. And the reason that we don't is that you have an unusual situation that has existed at the DEA since October of 2017 to the present time, when they have had the recommendation, the 8-factor analysis it's called, under the Controlled Substances Act, in their possession for evaluation. It is very unusual for that kind of a recommendation to sit at the DEA without there being some action over that period of time. Now, we know why that's the case, and frankly, it's because the FDA work in assembling the 8-factor analysis, wherein they lay out the case for the scheduling of kratom, is shoddily done. We know that the DEA felt very abused and were upset with the way that the FDA hung them out to dry in August of 2016, when the FDA recommended and the DEA went along with them in an emergency scheduling procedure that was published in the Federal Register. And that's what happens if they schedule under emergency scheduling powers or regular rulemaking. There is a notice that's published, that's a daily publication during the week called the Federal Register. What happened in 2016, it opened a 30-day comment period, although under the rule that was prevailing for emergency scheduling, that was not necessarily required, but the DEA accepted those comments. And during that period of time, they received a little over 6,000 comments from kratom consumers, and they were upset about what the proposed recommendation would do. And along the way, they also received a letter from 51 members of Congress and 13 senators, all opposing the procedural process that was being relied upon by the FDA and the DEA in the emergency scheduling process. Now, on October the 13th of 2016, the DEA closed the comment period and withdrew their notice of intent. Now, that's significant because it was the first time in 82, the use of emergency scheduling powers to schedule a dangerous substance, in 82 different times, the first time that the DEA withdrew their notice of intent for emergency scheduling, because they were convinced that the case that was made by the FDA did not meet the required threshold to demonstrate that there was an exigent threat to the public health from the availability of kratom. They then asked the FDA to conduct an expedited 8-factor analysis for emergency scheduling, they're required only to do 3 of the 8 factors that are contained in the Controlled Substances Act. And those 3 factors really were centered on the safety of kratom products and upon the addiction potential. The 8-factor analysis takes a much broader view of the science that would support the scheduling process. So in 2016, they asked the FDA for a full-blown 8-factor analysis to be delivered to the DEA by December 1st of 2016. That did not happen. But the DEA did open a extended comment period from October 13th to December 1st, during which time there were 23,232 comments that were received by the DEA, and that is the heart of the concern that the DEA currently has about the 8-factor analysis that the FDA finally delivered to them in October of 2017, more than a year after they asked for it, because those comments were from not only kratom consumers, they were from law enforcement officials, medical professionals, academicians, scientists, all of whom expressed deep concerns about the basis for which the FDA had made the case for emergency scheduling, and more broadly about the case against kratom as a dangerous substance. So in the present day, if the FDA were to decide to issue a Federal Register notice, they would open the 30-day comment period, which is required under the Controlled Substances Act. They would have the 8-factor analysis published in the Federal Register, so we would fully see what the FDA's case is in documenting the case for scheduling of kratom. We would also, by the way, be able to see the complete 8-factor analysis. We currently have, pursuant to a FOIA request, a Freedom of Information request, that was filed by a newspaper reporter and which was released by the FDA to them, even though it is a protected document during a rulemaking proceeding. Someone at the FDA responded and produced the 8-factor analysis. Now, I don't want anyone to believe that the FDA consistently is this bad at what they do, but even the FOIA only contained 1/2 of the 8-factor analysis. And what happened was whoever copied it failed to copy both sides of the document. It is obviously a 2-sided document. So the release of the 8-factor analysis every other page. But our scientific team was able to dig in to, even though only half of the document is currently available to us, we, by the way, are asking for the rest of it, and given that it was released, there is ample legal precedent for us to actually receive the entire document so that we can analyze it more completely. But the current 8-factor analysis, half of which we have, demonstrates how poorly crafted and formulated this 8-factor analysis is. So in the 30-day comment period, a couple of important things will happen. First, we're going to be able to directly attack the science around it and the comments that are going to be made by not only kratom consumers, but by scientists and researchers will go to the heart of the FDA case. Another important thing that will happen is that in that 30-day window, under regular rulemaking for a controlled substance recommendation, Schedule 1, any interested party can request a public hearing. Now, this is important because the first thing that everyone asks when I talk to them about the scheduling process is, will I lose access to kratom on the day that they publish the Federal Register notice? The answer to that is no. And in fact, until a final order is issued by the administrator of the Drug Enforcement Administration, you will continue to have access to kratom, because the scheduling order only becomes final after a very elongated process, which I'll describe to you here. An interested party is defined as someone who is impacted by the decision of the Drug Enforcement Administration to schedule kratom. So in this case, the best party would be a vendor, a retailer, or a manufacturer who is going to suffer significant economic harm as a result of this scheduling decision. We believe that as consumers, that we will have good standing to do so as well. We believe that there are scientists who would have good standing because they will be subjected to an onerous process in acquiring raw material of kratom if it were scheduled in order to conduct needed research. So we believe that multiple interested parties will apply for a public hearing, and we are confident that if there is a Federal Register notice announcing a scheduling of kratom, we'll get a public hearing. Now, what does that mean? It means that they will open up a quasi-judicial process where the case will be heard by a DEA administrative law judge. This case of kratom has attracted so much attention that we suspect that it will be the chief judge of the ALJ lawyers who adjudicate cases in the DEA who will take this case. The administrative law judge will conduct a judicial proceeding of which there will be ample opportunity for the interested party to seek discovery from the FDA about the basis for which the recommendation was made, and they will look closely at all of the safety data in each of the 8 factors. The safety data, they will look at the documentation the FDA has provided for documenting the abuse liability and each one of the categories that they are required to meet. At the point at which the administrative law judge then makes a decision, it is turned over to the administrator of the Drug Enforcement Administration for a final order. Now, how long does that take? It could be quick. There have been cases that have been filed where it can be adjudicated in a 4-month or so period. But because of the complexity of the kratom issue, because of the flaws that we have already identified in the material that has been presented by the FDA, documenting in each one of those cases, we believe that it will be a much longer process that could take anywhere from 4 months to 18 months in order for the Drug Enforcement Administration to actually make a decision. And then it might take another 2 to 6 months for the final order to be issued by the Drug Enforcement Administrator that would schedule kratom. So that process, we think, might take a couple of years. And traditionally, in complex cases like this, that's the time frame that is taken. So during that time, everyone will have access to kratom because it is not a banned substance until and if there is an adjudication and a final order issued by the DEA administrator. If there is an adverse decision by the administrative law judge, and prior to a final order being issued, or at the time that order is issued, the aggrieved party, in this case, if we got an adverse decision, we could file for a review by the district court, in the federal district court, arguing that the decision that was rendered by the DEA was arbitrary and capricious, and there are a number of bases upon which a legal challenge can be made against the decision that's made by the Drug Enforcement Administration, including a challenge as to whether or not they had properly met the criteria that's required under the Controlled Substances Act. We know that in the case of kratom, the science that has already been developed, the analysis of the safety data that is already available for the death cases that the FDA is claiming are associated with the use of kratom, and we know that the new studies that have been published by credible scientists that speak to the addiction profile are very important, and that they will become the substance for an appeal to be made. If an appeal is necessary, then it would take the federal district court probably 6 months to 2 years in order to adjudicate that case. So as you can see, there is no immediate threat to your access to kratom, and no one should worry about having to stockpile it. No one should worry about whether they're going to have access to kratom from vendors, because whatever your source currently is, and I would add one caveat, because the FDA is doing their level best to create a shadow ban on kratom, and they are using their regulatory powers to interdict the raw material supplies for kratom manufacturers, and they're doing their best to convince state agencies to go in and use obscure sections of the FD&C Act, which is the Food, Drug, and Cosmetic Act, in order to make a claim that anytime kratom is sold, that it, as a food, that it is a misbranded drug. And that, of course, is happening, we know, in Ohio right now. And as we've had early discussions with the Ohio Department of Agriculture, they've indicated to us that they're willing to allow Kratom vendors to sell Kratom as long as they don't make any claims or market it as being anything other than just Kratom. If they say it is a food or a tea, then they say that they'll ban it. So it's an interesting pathway for us to navigate, but the bottom line is that there will be opportunities for people to have access to Kratom if, and it is a big if the DEA were to publish a Federal Register notice for adding Kratom as a Schedule I substance under the Controlled Substances Act. So Pete, let's go to the next slide. I think that the most important thing here is that length of time, which I've already covered, which essentially shows you exactly how long it takes. That 30-day period, and Dave mentioned this a couple of minutes ago, we will have 30 days in order to marshal as many comments as we can in order to show the Drug Enforcement Administration and the Trump administration that there are people out there that are a part of this nearly 5 million Kratom consumers who object to this arbitrary policy taking place. So we know that in 2016, we got those the 23,232 comments. We need to do much better than that because the DEA is already sensitized to the fact that there are that number of public commenters. We need to make sure that we can double that and hopefully better. And by the way, we have the capacity to do that. We have seen the Kratom community grow significantly since 2016, almost as an adverse outcome for the FDA because of all of the attention they're giving to it. People are starting to notice it, they're trying it, and they're finding it to be very effective in the maintenance of their health and well-being. And for those people, the smaller segment of the Kratom community, that are using it to manage acute and chronic pain, and for some in the Kratom community that are exercising their legitimate freedom to use it as an alternative pain management therapy to opioids, or even as a step-down therapy away from opioids. Now, the reason I make that distinction about individual freedoms, that is not something that a vendor or a manufacturer can make. They are not, no manufacturer or vendor can make a health or a therapeutic claim under the current law, and if they do so, then they're subject to administrative action by the FDA and the Department of Justice. So there's a distinction between what an individual citizen can do in maintaining their own health and well-being, including the use of some substance or a dietary ingredient or a dietary supplement that they find to be effective in addressing some disease state that they have. It's just that the vendors and the manufacturers cannot make those claims. So we'll go through that first 30 days and we will do everything we can to make sure that we deliver to the DEA as many public comments as we can. We at AKA are going to be working with law enforcement associations. We're going to be working with scientist groups. We are going to be working with medical professionals. And we are going to do all we can to get those professional groups to comment as well. The community needs to get as many of their family and friends who, even if they don't use Kratom, but recognize the importance it has in your lives to call in and, or I'm sorry, write in and actually make their comments as well. So in that process, the Federal Register notice is the public comment. The ALJ public hearing, the administrative law judge public hearing, it takes that 4 to 18 months, that will be a legal proceeding. That is where our lawyers will be in there making the arguments before that administrative law judge that the decisions by the FDA that are embraced by the DEA are fundamentally wrong, that they contradict the science, and that they misrepresent completely what Kratom is and what its effects are. And then the DEA administrator decision gives us another opportunity to weigh in from members of Congress who support us, from the community itself, to again weigh in with the administrator before he affirms the decision. And then, as I mentioned earlier, the adverse decision triggers an appeal to the Federal District Court for an unknown time period, but we think it could easily be 6 months to 2 years. So all of that would, during that period of time, Kratom would remain legal. So let's go to the next slide, Pete. So what is the argument to deny scheduling? And this is an important point, and it, by the way, is something that every Kratom advocate ought to be familiar with. you should know that the FDA has failed to meet its 8-factor burden on the science in order to trigger a Schedule 1 for Kratom. Now, we all know that the FDA has made this a cause célèbre, but they keep making the same mistake over and over again. For example, the triggering event for the death data that the FDA has used includes the first reports of deaths that were attributed to the consumption of a Kratom product occurred in 2009 in Sweden, when over a 12-month period, 9 people died. And this got significant attention in the scientific and the regulatory community because that cluster of deaths were significant. And the commonality was that each one of those people who died were using a powdered Kratom product called Krypton, which was readily available on the internet. And so they drew the causation to that. That triggered the FDA's regulatory decision to disseminate widely throughout the government a safety alert. It went to the Drug Enforcement Administration, who added Kratom to their drugs of concern list. They added the discussion of Kratom to law enforcement officials in their regular conference calls that they hold with state and local police and troopers around the country. They talked about Kratom. They talked about the dangers of it. They talked about it's not being unsafe. And that spread the misinformation about Kratom itself. They also circulated this information to the National Institutes on Drug Abuse, NIDA. And NIDA added Kratom as a drug of concern to their drug facts report and up on their website. And so back in 2012 and that time period, you saw this broad-based information campaign that was actually a disinformation campaign. And here's why. In 2011, in a peer-reviewed published article, Kronstedt and his colleagues, who is a researcher based in Sweden, looked at all of those deaths. And what they discovered was, in examining the toxicology and the autopsy reports, is that the individuals who had consumed this powdered Kratom product, Krypton, actually died because that Kratom product had been adulterated with a toxic dose of O-desmethyl tramadol. That is the chemical, and it is a powerful chemical that is used in the production of the opioid tramadol. That's why those people died. So in 2012, when the FDA imposed an import alert on Kratom leaves and plants coming into the United States, it was predicated on a completely false position that Kratom had been responsible for those 9 deaths in Sweden. That's very significant as we make the argument, if we're required to do so, in any administrative law judge hearing or in a federal district court, because the FDA has an obligation to disseminate accurate information. And they should have known, because they are required to look at all available public literature. And a literature search easily would have revealed the Kronstedt study that debunked the theory that the FDA had about the dangers of Kratom and it being unsafe. And so from that point forward, in 2012, reaffirmed in 2014 with its import alert, all on the public record, and then again in 2016, they repeatedly referenced those deaths in Sweden. They did it again on August 31st of 2016 in their justification that they submitted to the DEA that was published in the Federal Register, which cited as the core group of deaths justifying the scheduling of Kratom were those deaths in Sweden back in 2009. So when we argue this case, we're going to be able to demonstrate that the FDA knew or should have known that the information that it was disseminating about these so-called threat to public safety and the deaths associated with the use of a Kratom product were wrong. And they continued to disseminate that information even though they knew they were wrong, because it buttressed the case that they were making, and it is a false narrative that is based on a false premise, and we think that that will be a powerful argument. Another important component of this is to understand the bias that the FDA has and why they are willing to violate the statutory mandate that they disseminate accurate information. That's in a law known as the Information Quality Act, which requires all regulatory agencies, particularly when they know that the dissemination of information will result in the formulation of a public policy that has significant impact on the citizens of the United States, they have to be accurate. And here they've ignored that obligation, and they've allowed the bias that they have against dietary ingredients and dietary supplements to buttress their case as opposed to good science. This all started back in actually the early 70s when the FDA tried to expand their regulatory authority over vitamins and dietary supplements. And that was a battle that percolated for 20 years. And during that period of time, the Congress tried repeatedly to give the FDA some limited authority over labeling requirements of dietary supplements and vitamins, and they tried to give them sufficient authority in order to get rid of any bad product. But the FDA was not satisfied. And so in early 1993, the FDA started a campaign to convince the Congress that they needed the regulatory authority in order to require all vitamins and all dietary supplements to be submitted to the new drug application process at the FDA. Now, back in 1993, there were no user fees, so there was no economic incentive that where the FDA would benefit from getting new drug application fees as they do today, but there certainly was this inherent bias that they wanted more power. And in those days, that more power meant more employees, a larger appropriation from the Congress, and greater control over the American economy. And there are people back in 1993, and there are people today at the FDA who are hell-bent to enact that kind of a regulatory policy because that's what they believe they need in order to protect the American public. All of that battle culminated, and by the way, at the time, the FDA was claiming that there was a significant number of vitamins and dietary supplements that were killing people when they ingested those products, and they claimed, and this is a familiar refrain, deaths associated with the use of vitamins and dietary supplements. There's no question, by the way, that there were some bad products, just as we see some bad Kratom products. But the FDA's obligation in those instances is to identify the bad actors and then to proceed with enforcement actions against them. Nothing has changed in the last 20 years in that regard. But Congress finally reacted in 1994 with the passage of the Dietary Supplement Health and Safety Act. It is called DSHEA. The FDA hated it. I personally sat behind Senator Hatch, who was the advocate for, along with Congressman Richardson in the Congress, as sponsors of DSHEA when they were testifying, sitting next to then FDA Commissioner David Kessler. And Senator Hatch publicly stated that it was a well-known fact that the FDA was biased against dietary supplements. And it was as though he had hit David Kessler in the face. Commissioner Kessler rejected that notion, said it wasn't true, and of course everyone knew that it was, and he said that they were only concerned about protecting the American public and wanted to keep people from dying from the ingestion of these products. The dietary supplement and vitamin community staged a national advocacy day where in each of the vitamins and dietary supplement stores there was a black cover, a cloth put over all of the products that would be banned if the FDA got its way. And it was significant. That result, and by the way, this is back in the days where there were no emails. The only way that you could effectively communicate with your congressional representative in those days was to send a letter or make a phone call. It was the first time in the history of the U.S. Capitol switchboard that the number of calls that came in about the DSHEA Act and about the FDA's bias against vitamins and dietary supplements actually shut down the Capitol switchboard. And the number of letters and the hundreds of thousands that poured across the transom into those offices resulted in the Congress passing DSHEA and limiting the authority of the FDA over vitamins and dietary supplements. Our problem, and it's a common one in Washington, is that there wasn't a crystal ball that allowed the Congress to see what the FDA might creatively develop in order to exceed its regulatory authority in the future, and that includes what we are seeing play out with Kratom today. They know that the argument they're making is false, and yet they can get away with it because of the regulatory imperative that they think that they have. So we will then be able to develop a very strong legal argument about the scheduling process failing to meet the Controlled Substances Act requirements. Just as an illustration, all of you have heard us talk about this before, but I think it bears repeating. Of the 44 deaths that the FDA finally settled on in October of 2017, and then reiterated and upgraded in February of 2018, of those 44 deaths, they need to be put into context. 44 deaths without any time limitation, with the FDA staff scouring the globe. So these are global deaths. Of all of the deaths that occurred in that time period, they were only able to find 44 deaths that they claimed were associated with the use of Kratom products. I don't mean to discount any death that occurs. It's unfortunate for the family and for the decedent that they have ingested a product that is somehow dangerous. But the FDA says it's because of Kratom, right? And we know that that isn't true. So the AKA commissioned Dr. Jane Babin to take a look at that data. I hope every one of you will go onto the AKA website and download that report, because it is powerful evidence of the bias that the FDA has. For example, we have a death that is reported there where the police reported that the person who showed up at the morgue had been shot in the chest and he died of a homicide. That was the report both from the police and the witnesses who saw the individual get shot at close range with a weapon. The FDA determined that it was a Kratom-associated death because in the toxicology screen, they found that the individual had drunk a cup of Kratom tea earlier that day. How in the world can that be in any way attributed to a cause of death? Another death was the police found a young man in an unfortunate circumstance because he had suffered from bipolar disorder throughout his life, had been released the week before from a mental institution, had a long history of poly-drug abuse and drug addictions, was found hanging from a tree. And when he was delivered to the morgue, the coroner determined it to be a suicide. The FDA concluded that it was a Kratom-associated death because that individual, I think, had 9 illegal substances in his bloodstream, and he had also used a Kratom product within a short period before his death. That's the basis for them calling it a Kratom-associated death. Another involved a German man who jumped out of a window, fell to the ground, broke his arm severely, suffered some internal injuries, refused any medical treatment because he was high on illegal drugs at the time. He went up to his room and was found dead several hours later with injuries that were the death was associated with the injuries he had suffered at the fall. He also had multiple illegal drugs in his system, and the FDA calls that a Kratom-associated death because he also had taken a Kratom product earlier in the day. That you can go through one after another. All 43 of the 44 were all associated with either poly-drug use, illegal drug substances, or the use of prescription medications that are contraindicated to be used at the same time that resulted in the deaths, or they were the use of products where the individual was trying to get high, like loperamide, because if you ingest enough loperamide, to get a high, you can kill yourself. And then they found some deaths, like the ones in Sweden, that were associated with an adulterated Kratom product where it was spiked with a very dangerous substance. As I mentioned earlier, the O-desmethyltramadol, if you took that same quantity and dosage strength of the O-desmethyltramadol that was spiked into the Krypton Kratom product, and you put that same dosage strength into a cup of coffee that you were drinking in the morning, you would be dead within a couple of hours. It has nothing to do with what the substance you add it to. It has to do with the toxicity of the O-desmethyltramadol. Yet the FDA persists in its notion that these are all Kratom-associated deaths. And I'll tell you one interesting thing about the report that Dr. Babin found, and that is that in 2 of the deaths that are reported, they were in Germany, and the headline of the published literature that was referred to and a part of the public record that the FDA submitted to the Drug Enforcement Administration, The headline said 2 deaths associated with the ingestion of mitragynine. But when you read the report, what the researchers did was they took the death that had the largest concentration of mitragynine to the point of publication of that article that was known to anywhere on the earth, and they contrasted it to the lowest dose of mitragynine when a death occurred, and they wanted to see if there was a relationship to the ingestion of mitragynine, one of the alkaloids of kratom that is subject to the FDA regulation or recommendation. They wanted to see if it had played any role in the death. And the conclusion of that article was that even at the highest dosage of this alkaloid mitragynine that was known to man at the time of that publication, it had no relationship to the death, that it was other factors that played into it. The FDA researcher, or perhaps I should call him a staff person because certainly it's not credible to call him a researcher, took that title of the article, included those 2 deaths, and made it a part of the 44, when in fact it undermines the argument that the FDA was making, because it showed that mitragynine was the alkaloid that they were attacking was not really responsible for the deaths. That will be a powerful argument before an administrative law judge or a federal district court judge, showing that the FDA failed to meet the standards required under the Controlled Substances Act. There are other deficiencies in the argument that was made by the FDA associated with those deaths, and so I again recommend you download it and you read it, because it's a powerful indictment against the FDA, and Jane Babham did an absolutely outstanding job in going through and analyzing each one of those deaths the way that they should have been by the FDA itself. Now, I said there were 43 of the 44. There is one death that the FDA claims is associated only with the ingestion of kratom, because they had a decedent who, in the toxicology screens, showed that the only substance that was in his bloodstream at the time of his death was kratom. Now, there are any number of explanations as to why a person might die and have kratom in their system that would be due to underlying health conditions that were unknown to the family, or not part of the medical record as well, or there could have been something that happened to that individual that didn't show up in a normal autopsy that would have caused the death, none of which are related to kratom. But what the FDA did was on February 8th of 2018, now that was 10 months ago, they said that they were going to investigate that one death, that it was of significant interest to them because it was the only death that had only kratom in the bloodstream. Now, I don't know how many of you are familiar with the FDA, but they have an army of bureaucrats and researchers that staff that agency. How in the world could they not have tracked down the information about that one death that they highlighted and said that it was the one that they were most interested in? And here we are 10 months later and no answer from the FDA, and we regularly ask them for that data. The truth is that they have found that there is no association with the death, and there's likely an explanation that they're not willing to release that would explain that death. But even if it were true, it is not the kind of statistical basis that meets the criteria under the Controlled Substances Act before a judge that would pass muster. It is also a requirement under a memorandum of understanding between the FDA and the National Institutes on Drug Abuse, NIDA, that NIDA will cooperate with and sign off on any scheduling recommendation that is made by the FDA to the HHS, to the Assistant Secretary of Health, who then transmits that recommendation to the DEA. It is important that the FDA sign off on that data. Our argument will be that NIDA clearly was not consulted about the scheduling recommendation with the kind of specificity that is required, because we know that NIDA does not agree with them on the death data. The reason we know it is that in June of 2018, the NIDA scientists, based on some new data that they had received that informed them better about the scheduling recommendation, published on their website and under the section on kratom and the subsection dealing with whether you can overdose on kratom, they said you can't. And the FDA immediately objected, and so NIDA agreed to take down, and many of you may remember this development, NIDA agreed to take down the language that they had indicating that you typically don't overdose on kratom. Now, it's an important argument because in order to justify its burden under the Controlled Substances Act, the FDA is going to have to document that kratom has the same effect on your respiratory system as classic opioids. That's where they get the connection to a Schedule I classification for kratom. We know that kratom, in fact, is not a classic opioid, does not have the same effects. It is not a full agonist on the mu receptors, pain receptors in the brain. And in fact, it's a partial agonist. And Dr. Andrew Krugel eloquently described this activity, and I can't do it because I'm not an expert in this field, but if you go to the AK website and you download the congressional briefing where Dr. Krugel stood in front of in 2 different sessions over almost 200 congressional staffers and explained that a partial agonist not only does not suppress the respiratory system, so there is not a kratom death that can be associated with that, but he also explained how, in fact, the partial agonist effect of mitragynine and 7-hydroxymitragynine actually puts up a stop on those respiratory suppression effects, and it has a beneficial impact. So, which explains a lot about why people that are using kratom in order to manage acute pain and chronic pain are actually very successful in doing so using kratom, and why there's so much interest in looking at alternative uses of kratom and whether it's going to be a non-addictive, effective use, and possibly even for a synthesization of a chemical formulation of the alkaloids in order to become a drug for specific therapeutic benefits. The NIDA scientist undertook a 2-month review of all of the data after the FDA objected. So you can see what will happen when we're standing before an administrative law judge, if that day ever comes, or a federal district judge, and we tell them NIDA, who is supposed to be a part of this analytical process and signing off on a recommendation, withdrew their analysis and support of the death, and on September 20th, they reposted what their analysis was in answering the question, can you overdose on kratom? And what they found was that most of the deaths that are cited by the FDA are actually a result of polydrug use. And they said there are some deaths that are associated with adulterated and contaminated kratom products. Those don't justify scheduling. We have never in the history of the United States banned a substance or put it on the controlled substances list because it was spiked or adulterated with a second a toxic dose of another substance. Never done that. And so they concluded that there is only one death that the FDA has cited, and there's no data yet to support that claim. So I think we have a very strong case that we're going to be able to make to the judge if we get to that point in the process. More importantly, though, I think it is prudent for us to accelerate our efforts as a community to convince the DEA that they should not even proceed to a scheduling decision and go through the comment period and go through the public hearing, but rather the best option is to return this 8-factor analysis submitted by the FDA and tell them to reevaluate it, and if necessary, to resubmit it. The reason that's important is that and even if you accepted most of what the FDA said, and it kind of squeaked under the wire for meeting the criteria in the DEA's mind for scheduling, there were 2 significant studies that were published after the submission of the 8-factor analysis by the FDA in October of 2017. The first was published, it's called the HEMBI study, in June of 2018. It was the first animal study that looked at the potential for addiction. It's called the addiction liability, and they used those animal studies in the traditional way to train a mouse that when they're subjected to pain, they hit a paddle and they self-administer what they think is going to be, and this is the way they test, an effective pain relief mechanism. When they studied that in the HEMBI study, and by the way, animal-controlled studies are as close as you can get to meeting the scientific standard for the safety of a product other than doing human clinical trials, which are required under a new drug application, they found that, in fact, that mitragynine was helpful, not harmful, that it was preferred as opposed to heroin because it had the kind of effects that were positive for the mice. That was followed almost immediately by a NIDA study that was an intramural study, meaning it was done within the NIDA framework by Dr. Yu and his colleagues, and they found exactly the same thing. The Hemby study, I think, studied morphine, and the U study studied heroin, both controlled substances, both Schedule 1, and they found that mitragynine was safe. It didn't have the addiction liability, and in fact encouraged additional research into this area. So we see dramatic changes in the science that undermines what the FDA did. If the FDA were acting in the public interest, they would have immediately requested to the DEA that they withdraw their 8-factor analysis and take it back voluntarily. But that would be a responsible act, and we know that the bias that exists at the FDA today is not one that allows for responsible actions, because they are engaged in a campaign of disinformation and a war on Kratom, and they're going to do everything in their power to undermine us. But it will be a powerful argument before an administrative law judge or a federal district court judge. So those are good things that are going to happen for us. We also know that the recent decision by the National Institutes on Drug Abuse to issue a grant of $3.5 million to the University of Florida to investigate Kratom as a potential effective, non-addictive pain relief therapy documents that there is significant acceptance and interest by NIDA in looking at this area in order to address what is an out-of-control opioid crisis. Dr. Jack Henningfield, who authored the original 8-factor analysis commissioned by the American Kratom Association, which in and of itself became a peer-reviewed published article a couple of months later, and in his subsequent review of the 8-factor analysis that was published by the FDA, that was analyzed by Dr. Henningfield and 11 other prominent scientists in the field, all concluded that in fact Kratom should not be scheduled, and more importantly, if you do schedule it, and this applies to every state board of pharmacy or any state that attempts to ban Kratom, you will actually increase the number of deaths that are associated with Kratom, with opioids. Because if you take Kratom away and you make it illegal, if you restrict its access to consumers, then those who use Kratom currently for pain management will be forced to go either to dangerous opioids, which we know are dangerously addictive and potentially deadly, so you'll increase the number of deaths associated with the use of these opioids, or you will force those people to the black market of Kratom products, which we know are full of those adulterated products that should, in fact, not be available to consumers. And they include things like fentanyl and heroin and morphine and all those things, which end up killing people, and desmethyltramadol. So that's the scientific analysis, and why all of us can take great heart in the fact that we have probably the strongest case known to man to challenge any decision by the DEA, if they were foolish enough to make it, to accept this deeply flawed analysis by the FDA. So I think that all of that taken together gives us a great platform to move forward. Now, I know that there is great frustration in the community because we would like to have this resolved, and we'd like to have an endpoint, and we want to have some assurance that Kratom will continue to be available. We are fighting battles that the FDA has started in Ohio. It's the FDA that convinced the Ohio Board of Pharmacy staff to propose scheduling of Kratom. I spent some time out in Arizona last week at the Arizona Board of Pharmacy with Dr. Oliver Grunman. Dr. Henningfield and I went to the Ohio Board of Pharmacy. When Dr. Henningfield and I walked out of the Board of Pharmacy staff meeting where we made the presentation about the safety of Kratom and the deficiencies of the FDA 8-factor analysis, we both concluded that we hadn't done very well. We were heartened by the decision that was announced by the Board of Pharmacy in Ohio that they are going to study it for another month. They're going to look at the comments more seriously, and they're also going to work with the Ohio Agricultural Department, who had been off on this foolish shutdown of Kratom vendors, again, all instigated by the FDA. When Dr. Grumman and I were at the Arizona Board of Pharmacy meeting, the Arizona Board of Pharmacy had previously recommended to the legislature to affirm their right to schedule Kratom. Dr. Grumman made a powerful case as to why that should not happen, and they agreed to form a study committee, which they've invited the American Kratom Association to participate in order to revise and hopefully step down from that recommendation. We see this battle occurring in other states as well because the FDA has been so aggressive. I went up and visited with Senator Rick Jones in Michigan, who announced on radio that he was going to sponsor a bill to ban kratom. And it was only after we sat down with him and with the Michigan Prosecutors Association and with the coroners there and told them what the set of facts were about kratom, showing them that it was polydrug use or adulterated products that caused these deaths. Senator Jones agreed to sponsor legislation that is called the Kratom Consumer Protection Act. And it's filed in Michigan. A model of that bill is being currently evaluated in the Utah Legislature, Legislative Counsel's Office for filing. And we are working with several other states to do the same thing. We're working in the state of Wisconsin to rescind their ban on the same basis because the science works for us. We're working in Arkansas to do that. Dave Herman has commissioned me to spend a lot of time in these states in order to fight this battle. And it is important to note that since the announcement of the proposed scheduling ban in 2016, we have won every state battle where a proposal has been made to ban kratom. It is true that we lost in 7 states after the 2012 import ban was announced by the FDA, and they filled the pipeline with disinformation. But we're working aggressively on 2 fronts: to rescind those bans that exist on those products, on kratom in those states, and to prevent bans from being put into place. A couple of interesting facts about the states that did ban it. State of Tennessee actually banned the synthetic analog of kratom, not the botanical. And because of a test case that was run through the courts, the Attorney General ruled that only synthetic versions of the 2 alkaloids, mitragynine and 7-hydroxymitragynine, are what are illegal. So in the state of Tennessee, the botanical plant kratom is still legal, so that reduced it to 6. But in Rhode Island, without any public comment sought by the Department of Health, they banned kratom at the behest of the Food and Drug Administration. We're working now to get that unwound as well because we don't think the procedures were followed. We're working with the governor's office in Arkansas to unwind that ban because when that occurred, the health department did publish a notice, but it was in such an obscure way, there wasn't a single comment about the fact they proposed to ban it. So we've got an opportunity here to really make some changes. That is only possible because of the people that are on this call and many of those who remain our supporters but weren't able to join today, but hopefully will view it later. I thank you for that because it is a battle that we are winning, and with your support and with your financial support, we were able to continue these battles and show up where we need to be in order to fight the battles. And it's a tribute to Dave and his leadership with the AK team that he's willing to deploy an excellent team of lobbyists. I'm not talking about myself. There are lobbyists in many of the states and scientists around the country so that we can make these arguments and powerfully argue that the decisions by the FDA, this crusade against kratom, their war on kratom, is unfounded and it needs to be rejected. And we're building that case strongly as we've gone forward. I know I've covered a lot of ground here, and I apologize for taking so much time, but I think that to the extent that you can be informed about these arguments, we are going to be able to carry this fight directly against the FDA, to expose them for the bias, to expose them for the disinformation campaign, which in and of itself is illegal. And when we get to the scheduling process, we're going to do something else. We're going to ask you to engage your Congress representatives, senators and congressmen and women, in order to do the same thing we did in 2016, which is to get the Congress pushing back against this arbitrary act in fulfillment of the FDA's desire to ban kratom. So I'll end with that and turn it back to Dave and to Pete and look forward to answering any questions you might have.
I have just one short comment for everybody. One of the great joys of my existence is I get to hang around people like Mac. I get to hang around with people like Jack Henningfield, Jane Babin, some brightest and the best who are dedicated to this cause. We had a culmination of weeks of work and comment that ended in a 6-hour meeting yesterday that covered a lot of different disciplines and what to do. Because most of this was above my pay grade, I said, guys, would you please dumb it down for me so I understand what it is we're going to do and when we're going to do it. And the determination was made, the time to do stuff and start doing stuff is right now. Let's hit the ground running in the event something bad happens. And if it doesn't happen, we've energized a lot of people to very useful purpose. What I was told back from a dumbed down perspective is there's 5 key areas we need to deal with. And if you can picture these as headings on the top of a page, under each one of these, you're going to see a number of items, and I'm not going to go into those. But the 5 key areas are legal. We're researching that from 1N to A to Izzard. Lobbying, and you can hear the quality of our capability through the things that Mac shares with you. Science, because that's the one thing that really is compellingly convincing that the FDA is just wrong. PR, because we've got to tell our message to people. And then we come to the final and 5th item, and that's the community. We depend on you. And yes, we want your donations because we fly on that. But we depend on you. And now's the time where all your frustration can be let out. All the things you've been worried about can be moved forward because you are participating from this step forward to keep Kratom legal. And at the end of the day, that's all any of us want.
Okay, Dave, thank you for that. Mac, thank you for that. I appreciate you going through that information. We did have a list of questions, and I want to let everyone know that, first of all, thank you for sending your questions into me. I have read every single question that have come in. Due to some time constraints, we're not going to be able to address all of them, but I did want to go over some of the questions with Mac and Dave. Mac and Dave, I know that you maybe have addressed some of these issues already. But I wanted to read some of these for the folks who sent them in. And if you could just keep your questions as concise and to the point as possible, then we can get through them. Again, Mac, I know you talked about this. Dave, I know you talked about this. How long will people have, if it becomes scheduled, how long would folks have to get rid of their Kratom supply?
So the answer to that is pretty straightforward. There's a 30-day period where technically they could move to scheduling right away. We will interdict that with a request for a public hearing, and that triggers the what will essentially be a 18-month to a 2-year process, and then we'll go to federal district court if we get an adverse reaction there, or adverse decision there at the DEA, and that all during that period. They cannot take Kratom off the marketplace, so there's no need to overreact now and start hoarding it or buying a big supply. You're going to be fine going forward. The only caveat to that is that the FDA is going to continue to do what they can to shut down supplies of Kratom raw materials, and we're going to have to watch that because that impacts not only supply but price. But we're going to do our best to keep fighting back.
Is the American Kratom still seeing vendor shipments being seized? Is that still an issue that vendors are dealing with?
We think it is an issue, but there's a big issue that ties all this together. In 2012, the first import ban was put in place, and it was renewed in 14 and 16. With the import ban, and Matt covered a lot of this, there was the ability or the need or requirement for DEA to list Kratom in their drugs and chemicals of concern. When that happened, you then had reputational risk to a lot of different vendors in a lot of different environments. So now you have credit card processors who look to reputational risk as a reason not to deal with Kratom vendors, and they're doing that based on the drugs and chemicals of concern, which is a direct impact from the import ban. We're working with several law teams. We're investigating how to do this. I think I get 10 emails a day saying, why don't you just sue them? Well, it's a little harder than that. But we want to get them into a courtroom. We're working toward that because what they're doing is just plain wrong.
And I would add that a litigation is expensive. So you want to pick the case. And there's an issue here about whether you sue them for the import ban, which we likely would lose because the courts would grant significant deference to the regulatory decision of the FDA, as opposed to a vendor who gets a product sued or a manufacturer, then suing the FDA for that action, because that shifts the burden of proof heavily to the FDA to justify what they did. So we're carefully analyzing right now with expert lawyers about how we can find the case that would give us the best opportunity to challenge what the FDA is doing.
In your opinion, does the recent grant to Dr. McCurdy from NIDA mean something significant in the fight to protect Kratom?
Oh, I think it's very significant. I think that although it isn't the cause that we would be looking for, because there's a lot of emphasis on a potential opioid withdrawal tool, we ultimately think that is one of the benefits that will come from Kratom. But you can't, on the one hand, say that this needs to be researched, and on the other hand, put it in Schedule 1, which stops research. Because the license for Schedule 1 research is extremely restrictive, and the ability to get consistently good product to the researchers becomes more and more difficult. So we think that's opening the door to a good dialogue, and we hope to have a meeting with NIDA to discuss this further.
Someone reached out and said that they have reached out and communicated with their senator multiple times, and they continue to get a canned response. What should they do in that situation?
Well, I can tell you that that's not unusual, by the way. But your letters are important, because what happens is there's a tally that's kept in the correspondence control rooms of every Senate office, and although the staffs are smaller on the House side, they do the same thing. So they're checking a tally saying, oh, this is about Kratom. And even though the answer doesn't seem responsive, your letters are important because cumulatively they add up. I have been in multiple offices while we've done call-in campaigns and watched as the front office people would answer the phone and express their frustration with having to answer repeated calls over and over and over again. I can also tell you that I have worked with a congressional office that sent out a constituent letter that was flat wrong about Kratom. They actually said that it was controlled by the DEA as a Schedule I substance. I went in and I talked to them. I explained it. I told the legislative assistant that they were wrong. They took notes, said that they would correct it. A similar letter was issued by that office 2 months later from another constituent asked about Kratom. It was the same letter. So there are inefficiencies built into the system. We work every day to get accurate information out there, but don't be discouraged by the fact that the Senate or House offices appear to be dumb. They're not dumb, but they may be inefficient. And so we just continue to work around that. But let us know when you get a response like that, because it helps us go back into the office as a reason to discuss it and say, hey, we got this response. We want to bring you up to speed and show you the latest science on Kratom. So it's a great entree for us. So keep us posted on those things.
Also, there's not enough hours in the day to communicate with everybody that has an interest, but there are enough hours in the day for us to read whatever you send us. So don't feel frustrated if you don't hear from us. We read it, we note it, and we try to take it in and use it.
Are there any concerns that the DEA might choose another type of scheduling, another classification besides a Schedule 1? Can they go with any other scheduling class besides 1?
No, but they can do. They can use the emergency scheduling authority granted by the Controlled Substances Act that would essentially bypass the comment period and create more problems for us, and create problems with the litigation part of it. It is unlikely, I would say extremely unlikely, that they will do that given what was done in 2016 and how they got burned by the FDA with their first emergency scheduling attempt. What is before the DEA now in an official document submitted by the DEA, or by the FDA, is an 8-factor analysis, which is regular rulemaking, which opens up all of the avenues that we've talked about. So I don't think that there's any chance that the DEA will try to schedule it any other way. They are precluded by law from any other scheduling level. There's 5 scheduling levels. They can't use any others because there is no medically approved use for Kratom, so they are stuck with doing Schedule 1 or not at all. And we think, of course, the right decision is not at all.
Okay. With the Democrats taking control of the House, do we see that changing the fight in any way, with them taking different leadership positions and different leadership positions within the various committees?
Okay, this is, I know this is going to offend people because I actually produced a legislative report where I opined that the change in leadership on the House side was going to have a positive effect on the battle to keep Kratom legal. And it wasn't a political argument, by the way. It is undeniable that it was a Republican chairman of the House Judiciary Committee who rammed through the SITSA bill despite our objections, and by the way, despite our credible objections, who then hoodwinked the Energy and Commerce Committee staff to send it over without a hearing because there was joint jurisdiction under the, because this law impacted both Energy and Commerce and Judiciary, to the Rules Committee. And then it was the Republican chairman of the Judiciary Committee who ramrodded it through the Rules Committee without allowing for the amendment that we thought was appropriate and was appropriate in order to modify very bad language in SITSA. We had to go to the Senate to fight that and get it stopped. It is undeniable that there is a bias by the Republican leadership. I'm not saying the Republicans are bad. I'm saying that the people that were in charge had this bias and they were stalking for the FDA and the Drug Enforcement Administration. We have a much more favorable environment with the new leadership in the House because the platform of the Democratic Party is more reasonable to the use of botanicals, including marijuana, by the way, so they've plowed the ground for us. But there's a more reasonable view about the appropriate level of regulation that should be imposed on botanicals. And I think that we have a better place to work on in a democratically controlled House. And I speak to you as a Republican. I'm not saying that the partisanship means anything. It's just the philosophy that is going to be implemented. And we needed that change, certainly in the Judiciary Committee, because of the bias that they were exhibiting against our arguments.
This is a little bit of an unusual question, so I'm hesitant to throw a fast or a curveball by you here, but this one definitely stood out to me. If Kratom is scheduled, would the tree itself be illegal to have on your property? I don't know the answer to that. I really don't know. Oh, Mac, please tell us.
No.
Okay.
The scheduling recommendation speaks to two alkaloids that are a part of the kratom plant, mitragynine and 7-hydroxymitragynine. There are various pronunciations of those terms, by the way. So you might hear different ways of it's expressed. But the plant's not illegal. It is the alkaloids in the plant that are present in any product that is available to people. So now, theoretically, could a law enforcement officer who decided to be enterprising and could a prosecutor decide to get crazy? Yeah, they could, but that would be a very interesting case to be heard because it's just unreasonable. Even for the crazies, it's unreasonable. Crazies mean the FDA. So yeah, I don't think that you have to worry about a plant, but they could reasonably ask, well, why are you growing this plant, and what is your intent to use it?
Show us all your leaves.
So that's an interesting question.
When are we planning the big rally in Washington, D.C.?
That is in the hands of the DEA. And that would be triggered by a decision by the DEA to schedule. Now, in the discussions that we had yesterday that Dave referenced, where we spent 6 hours collaborating with other advocacy groups, we developed a consensus which is going to be put into a document of recommendations on how we should approach this. And we think that there is a growing sentiment that we might be effective in convincing the DEA not to schedule if they're currently in their current status where they're looking at it but not sure what to do. And maybe that's our triggering event. So people should stand by. We may elect to use that strategy and decide there's critical mass where we would convene a rally in Washington. And by the way, I've strongly recommended to the AK leadership that we not support rallies for the sake of having a rally without there being a connection to a legislative event. And I know that was somewhat controversial. Dave himself has said many times, we're not against rallies. We think they're important. We think they should be timed to a specific event and not just the convenience of the people that may participate in the rally. The government's good at putting together dates for things that become very inconvenient for the citizens to participate in it, but we've got to stretch to make that happen. So I think that people should stand by and wait for advice, but I think we're obviously going to have a rally, and it will be determined by what the best strategy is to impact the decision that's going to be made by the DEA with respect to Kratom.
And one of the last questions I have here, Mac, this is directed to you. I've gotten this request a couple times. How did you get involved in the fight to protect Kratom?
I worked with I've been involved in this public policy arena with the FDA for a long time. I was the chief of staff in the Reagan administration at the Department of Health and Human Services when the FDA went after Herbalife, claiming that it was killing people. And in that case, I asked for the scientific justification because I was responsible to clear all testimony being provided to the Congress from the Department of Health and Human Services, of which the FDA is one of the agencies under the control of HHS. Commissioner Frank Young brought me the justification for what was claimed to be 7 deaths associated with the use of Herbalife products. The first one was a morbidly obese woman in Florida who weighed 425 pounds, who had been told by her doctor that she had to lose 40 pounds or she was not going to be able to go off her cardiac medication that was necessary to protect her life at that point. She was approached by an Herbalife representative who told her that if she were to purchase Herbalife products, that she could lose 40 pounds over a 4-month period. Well, that seemed to sync up with her. And so she bought a 4-month supply, decided if she took all of that in 1 month, she could lose 40 pounds in 1 month. And she also decided to quit taking her cardiac medication because she knew that her doctor had said if she lost 40 pounds, she wouldn't have to take that anymore. And she died 2 weeks later of a heart attack. And the FDA said that was a Herbalife associated death. Second one, and this is as far as I got, by the way. Second one was a kid in New Orleans, 18 years old, stepped off the curb, got hit by a bus and killed. He was at the time using Herbalife products for weight loss. He also was a known drug abuser, and he was impaired with a illegal drug, street drug, at the time he stepped off the curb, and yet the FDA claimed that that was a Herbalife related death. So does that show you the pattern at the FDA? They'll say bizarre things. So that's how I first got involved in it. I then, after I left the government, worked in the government relations field and worked with the dietary supplement industry when the DSHEA Act was heavily involved. I had run Orrin Hatch's campaign for the U.S. Senate. He was the champion for the dietary supplement industry. I had clients that worked in this area. I was heavily involved in DSHEA. And so when the Kratom issue came around, I was hired by one of the vendors who was looking at applying to the FDA for approval of a new dietary ingredient application that used Kratom, and the FDA denied it. And I think I want to make an important plug here as to why that was necessary. In the DSHEA Act of 1994, there was a provision in there that said that if there could be demonstrable commerce, meaning that if we could prove that Kratom was being bought and sold in the United States prior to October 15th of 1994, it would be grandfathered in as a dietary ingredient. We have never been able to show that documentation because most of the Kratom supplies were brought in by smoke shops or by ethnic delis from Southeast Asia, and they didn't have the sophisticated software programs that would give us a good track of those transactions. If there is anybody listening to this call, if you know of any kind of documentation that exists of a transaction in which Kratom was bought or sold that you have access to, we would love to get that, because that would be a seminal event in being able to demonstrate that the Kratom products are grandfathered in, and it would create a real problem for the FDA and give us a pathway that is currently not available to us. We know, by the way, that there was significant commerce of Kratom during that time period. We just haven't been able to document it. When I was at HHS, there was a decision that was rendered by a district court that said that the FDA was required to accept global commerce. And certainly we can document in Southeast Asia, where Kratom has been used for centuries, all of that documentation where it was used as a food, where transactions are common, but the FDA refused to accept it from the client that I had as a justification for approving an NDI, new dietary ingredient application. So that's how I got involved. And so when the scheduling recommendation was made in August 31st of 2016, I received a call from friends I'd made in that industry, was asked to join the American Kratom Association team. I did so, and the rest is history. And I today, as a firm advocate, having learned a lot about this process and seeing how unfair the FDA is consistently towards botanical products and other dietary supplements, it's about time that we took this fight and just rammed it down their throats, because at some point they're going to realize it's no longer worth the fight. So hopefully we can accomplish that.
Very good. Well, I'll tell you, right when I asked you that question, I received a flood of emails asking me to ask Dave too. Dave, how you got involved, and a couple people wanted to know, have you ever tried Kratom before?
I think the last time I took Kratom was about an hour before this call.
Okay.
And I always say a family relative. My wife has had 2 lumbar fusions, double cages. She had a cervical problem. And the net effect was we ended up being great friends with hydrocodone and Percocet. She's never gotten addicted, but I've always been scared of it. And so I've done a lot of looking around at what alternatives are there. A good friend of mine who's on this call with us told me about Kratom, and that the would be useful to have someone with a business background. I was an investment banker and ran hotel companies before I got into the nonprofit world. And then I ran a large nonprofit that was 25 countries, 67 member organizations. So my background was there. And he said, you know, it would be helpful to have somebody on the board that had some business background, that these people were floundering. So that was in May of last year, not this past one, but the one before. And I got there and I looked around and everything looked kind of weird and new to me. And that didn't really matter, because 2 weeks later, Susan Ash quit. I hardly knew her, never met her in person, and she gone. And so at that board meeting, a couple of those folks looked at me because of my background and said, would you do this? And they openly say now that they thought I'd say, well, I'll think about it, or I won't do it, or whatever. But, you know, in a moment of total insanity, I said yes. And so there you go. That's how I got here. And since then, the cause has become important. I think of Mac and Pete as friends, not work relationships. I dearly love learning, and being involved with all the scientists and all that goes on here is terrific exercise. As far as the Kratom itself goes, my preference is triple O capsules, 4 at a time. I tend to take some extracts on occasion when I play golf for a mild boost, energy boost. My favorite joke these days, and it's not funny, but I can't help myself sometimes. I'm sitting there playing golf with guys, and I'll take a bottle of whichever elixir I've got, and I'll look at them and go, am I high yet, guys? Because the silliness of that is beyond words. So at the end of the day, I'm wrapped into this cause. On a personal basis, I use it, but that's not how I got here. I got here because I wanted to help my bride. We've been married for a mere 45 years, and so that's an important part of my life. So what I found here, and it's funny, I talked to somebody earlier tonight, and they said, well, how much detail are you going to go into tonight? And I said, well, Mac is going to cover the universe as we know it, because we want everyone to see how engaged we are in the process. And that you may see an email come out from us that's 2 pages, but the conversation that led to that and the study that went to that was very, very arduous. So we've developed a team, I think, and the board members are terrific. They're very helpful in an understanding of what these efforts are. And there's been a lot of change that happened. But we're here to move hearts and minds. We're here to change the world. And the excitement of that has kept me going through this period when I got here quite by accident.
So if anybody wants to meet this rock star, I'm sitting in a hotel room in Atlanta, Georgia, because tomorrow Dave's going to testify before the legislative committee in the Georgia legislature. So if you live in Georgia, come down and see us, because it would be a great opportunity to show those legislators that people are opposed to what the FDA is trying to do.
And Mac, that's 10 o'clock tomorrow, probably at the Capitol, room 450. You probably need to arrive a few minutes before that, right?
That's correct. And the benefit will be that you can shake Dave Herman's hand.
Very good.
And that will run off anybody that was coming, but thank you.
Well, Mac and Dave, thank you very much. I'd like to thank everyone who took the time to submit questions for this webinar. I appreciate everyone sticking with us. A lot of great information that was shared here. As Mac and Dave said, we really appreciate all the support you have given us. We are committed to this fight. We will not give up. We feel like we have a strong strategy, but that strategy can only be implemented through the support of all of you. And I want to thank all of you, and on behalf of Mac and Dave, want to thank all of you for your support. Mac and Dave, do you want to say anything else before we end?
I'm done.
We're done.
Thank you very much, everyone. Have a good evening. Thanks a lot.
Thank you all.